Yes.
Item 1 for admission.
What is the stage?
My Lord, I filed my so-called reply on 11/9/2024.
Yes. So rejoinder? You had prayed for time to file your rejoinder affidavit.
Apologies, my lord. I was unwell, so I could not file any rejoinder.
So further time.
Yes, my lord.
Miss Valentina Laldinpui, learned counsel for the petitioner, seeks how much?
2 weeks' time, my lord.
Further 2 weeks' time to file their rejoinder affidavit to the counter affidavit filed by the respondents. Full stop. Ms. Zairam Sangpui, learned CGC, appearing on behalf of the respondents is present. In view of the above, list after 2 weeks.
Item 2.
So, my lord, if this matter may be taken up after 3
So
weeks.
you have this by way of a this thing affidavit, isn't it?
Yes, my lord.
None appeared for the petitioner, while Ms. Caroline K. Lalungoipui, learned government advocate, submits that steps have been taken by the respondent slash school education department, and she has prayed for time to file the counter affidavit accordingly. In view of the above, list after
After 2 weeks.
2 weeks.
Item 4.
My Lord, I filed my power for respondent.
Oh, so you're appearing for CBI.
Yes, my Lord.
Now, what is the stage?
My lord, LCR may be requisitioned, my lord.
LCR has not been called for?
Not yet, my lord. Since up till today, none had appeared for the respondent.
Okay. Yes, Mr. Lal Fakoma, learned counsel for the appellant is present, along with Ms. Hazairam Sangpui, learned counsel for the respondent. It is seen that the appeal has been admitted. LCR is to be called for. List after 2 weeks.
Obliged.
Obliged.
Item 5.
My lord, I am yet to receive Parvai's comments.
Mr. Lal Pianfe Latongtu, Learned Counsel for the petitioner is present, while Ms. Caroline K. Lalungoipui, Learned Government Advocate, has prayed for further time to file their counter affidavit since she has yet to receive parawise comments. In view of the above, list after 3 weeks.
Yes, my lord.
My lord,
Obliged.
maybe may I pray for 2 weeks because it is a cover matter.
Okay, list after 2 weeks.
For order. Item 6.
One minute, Mr. Pianfela, just come back. You're saying it's a covered matter. Have you mentioned the judgments?
Not yet mentioned, but I'm bringing the judgments, my lord.
Then we cannot reflect that.
Oblige, my lord.
Item 6.
Yes, Your Lordship, this is an application for bail. And the matter has been discussed earlier, but I was given direction to serve my authorities on which I relied upon. So I'm submitting some citations.
Okay. So what is the matter about? Let's see. What
The
was seized?
5 kgs of heroin was seized, 5.8.
From?
It was seized from the Ashok Leyland truck, and the petitioner herein was the handyman of the truck, handleman.
Okay.
And he was, as per the instruction of the secret compartment was located inside the truck. So the excise personnel had instructed him to open the secret compartment. So his involvement was to that extent of opening the compartment and riding inside the vehicle. So, Your Lordship, my contention is that he had no knowledge of the seized contraband substances. It has been stated by the in the by the seizing officer, his evidence has been adduced, and he has stated that his involvement is not confirmed, and that in the additional affidavit, I had submitted his examination in chief.
Okay. Where is it? Here.
His
Let's see
cross-examination.
that.
It is at page last page of the additional affidavit.
Seizing officer is F. Lal Nuntluanga,
Yes.
is it?
Yes,
So let's see the in chief also. Maybe you can read from para 5.
Yes, Your Lordship. At around 11:45 p.m., we saw the suspected Ashok Leyland truck at Zemabok East near petrol pump. We stopped that vehicle at the main road and parked at the said petrol pump and apprehended the driver and its handleman immediately. After arranging civilian to witness proceedings at Zemabok East, we interrogated the driver and its handleman and recording grounds of belief. We conducted search of the vehicle along with the civilian. Later, we recovered 323 showcases containing suspected heroin weighing 3.775 kgs from specially made concealment at the toolbox of the said Ashok Leyland. We also recovered another 178 showcases containing suspected heroin weighing 2 kgs from the suspected made concealment at the cab carrier of the truck. During search, we also recovered the vehicle number plate bearing so and so near driver's seat. I therefore seized the suspected heroin weighing 5.8 kgs, kept in 501 showcases, wrapped in 49 black colored polythene, and Ashok Leyland truck bearing so and so with its ignition key at 12 a.m. I also arrested its possessor and carrier, the vehicle driver and his handleman, MD Nazimul Hussain Barbuya, son of Abdul Jalil Barbuya of Dashin Mohanpur, so and so, and Abdul Kalam Laskar of so and so on the same date and time. We interrogated the said driver and handleman. I found out that there are some other person who were deeply involved in this heroin trafficking, and they were not far from the place of occurrence The duty team was split into two teams. Find the other person at Zemobor locality. Luckily, on 11/12 at 2 a.m., we saw another suspected heroin possessor, Kutbul Alam Laskar, son of so-and-so, resident of so-and-so, and Sulkur Ali Mazumdar of so-and-so. After the driver and handleman confirmed they are involved in the case, and the accused, Kutbul Alam Laskar, was the mastermind of the case, I therefore arrested Kutbul Alam Laskar of so-and-so and Sulkur Ali Mazumdar of so-and-so on 11 June 2023 at 2 a.m. in the presence of the same reliable civilian witnesses in connection with the previous seizure of 5.8 kgs of heroin at 12 a.m.
Okay, so what do you want to point out in the cross?
In the cross-examination at the last page, Your Lordship, if I may read, it is a
Yes.
fact that cross-examination for accused counsel for Abdul Kalam Laskar. It is a fact that Abdul Kalam Laskar was handleman of the seized vehicle from where the SA was recovered. I cannot say as to whether Abdul Kalam Laskar was the owner of the Ashok Leyland. It is a fact that we had directed the driver and accused Abdul Kalam Laskar to open the secret compartment, and upon the instruction of the driver, the accused Abdul Kalam Laskar opened the secret compartment from where the SA was recovered. I cannot recall as to whether there were any incriminating evidences in the phone calls or messages of the accused Abdul Kalam Laskar. It is a fact that there are no documentary evidence to show Abdul Kalam Laskar had conscious possession of any contraband substances in the complaint sheet. So, Your Lordship, my contention is that in cases such as NDPS, the burden of proof is more stringent than other cases. So in this case, the seizing officer himself has created doubt, whereby he has stated that there is no proof there is no concrete proof that he had any involvement in the instant case. So there can be no conviction in such instances. So there is no requirement of keeping the accused, the applicant, incarcerated at this stage, because the seizing officer himself has stated that the involvement of there is no concrete evidence to sustain the involvement of the petitioner in this case. And Your Lordship, one other contention is that one of the co-accused, Mr. Lalram Mwana, who is the accused number 5, I think. No, 6. He has been released on bail by this honorable court. So the principle of parity may be invoked, and he may also be released on bail. And another contention is that the petitioner
Where was he
By
allowed
this-
to bring? On what
I had
grounds?
submitted the
Oh, money.
Ramwana, yes.
Yes, the money. So his situation and the present situation, applicant is different, isn't it?
A little bit, Your Lordship.
Then you have also produced one more, all my judgments, huh?
2 more.
Then what about La Lompuya? Is he
La
also a
Lom- no, no.
co-accused in this case?
No, Your Lordship, this is an entirely different case. If I may direct Your Lordship's attention to para 4.
Para 4, okay. Yes.
The learned counsel for the petitioner submits that the instant petitioner is a permanent resident of so-and-so and is innocent of the charge under section 21C. He further submits that the instant petitioner has been in judicial custody since the date of his arrest. The learned counsel submits that even though the charge sheet was filed on 19/7/2022, the trial
Okay,
against the accused
this is the submission of the council. So why did I grant, this court grant bail? Let's see that.
at para 7. Having heard the submissions made by the counsels for both the parties, this court is of the view of the decision of the apex court in so-and-so has held that during the course of the hearing, we are informed that the petitioner has undergone custody for a period of 1 year and 7 months as on 9/6/2022. The trial is at preliminary stage as only one witness has been examined. The petitioner does not have any criminal antecedents. Taking into consideration the period of sentence undergone by the petitioner and all the attending circumstances, but without expressing any views in the merits of the case, we are inclined to grant bail to the petitioner.
Okay, so para 8, one is he's been in judicial custody for more than 2 years.
Yes.
And the second one is he is from a permanent resident of Champai.
Yes.
Okay, and he has produced his EPIC card.
Yes.
Now, in your present case, he has been in judicial custody for how many years?
He was arrested on 11/6/2023.
23. So
Yes.
it's 1
1
year,
year and 4 months.
1 year, 4 months. And is he also a permanent resident of Champai?
No, Your Lordship, he's a permanent resident of Qatar, Assam.
Qatar. Okay, so it's again different, isn't it? No, I'm just trying to find out why are you citing these cases and are they similarly situated? So the two cases which you have cited is not actually applicable in the instant case
Lordship,
because the
cite-
situation is slightly different. Now you have cited another case. Let's look at this. CC.
Hmm.
Where's the relevant portion?
From para 7, Your Lordship.
7, okay.
The prosecution case appears to be that the appellant had gone to meet the main accused, Arif Khan, for the purpose of obtaining contraband and then sell the same on commission basis. It seems that the contraband was in conscious possession of the main accused, Arif Khan. The said main accused, Arif Khan, has been admittedly granted interim bail by this court, right, so-and-so, pass in, so-and-so. It is informed by the learned counsel for the parties that the appellant has on date spent more than 1 year and 11 months in custody. The investigation is complete, but framing of the charges is yet to be done. The conclusion of the trial will thus take time. There are no criminal antecedents. It is seriously debatable question of fact whether the appellant was also found in conscious possession of the contraband, but such a question of fact will obviously be determined by the trial court at an appropriate stage. That being so, it seems to us that as of now, the twin test of Section 37 of the Act need not to be invoked against the appellant, taking into consideration the totality of the circumstances, especially the period of custody undergone by the appellant. However, without expressing any views on the merits of the case, the appeal is allowed. Accordingly, the appellant is ordered to be released on bail, subject to his furnishing of bail bonds to the satisfaction of the trial court. So, Your Lordship, this judgment has taken into consideration the duration of
Besides the other grounds.
yes.
Oh.
In both the cases, the Lal Ompuya and this one, it has taken into consideration the duration of the incarceration.
You have been
and
charged
the-
under Section 21, isn't it? 21. So Section 37 has to be taken into consideration here. Here it says that Section 37 need not be invoked against the appellant. And the seized article is 340 grams of smack morphine.
Yes.
Yes. Anyways. Anything else?
So, Your Lordship, my main grounds are that he was only the handleman and he had no involvement. There was no conscious possession on his part. And that he has been incarcerated for more than 1 year, 4 months. And that based on the citations submitted, liberty may be given to the petitioner to be enlarged on bail, considering his extended period of incarceration, and only one witness out of the 14 prosecution witnesses have been produced. There are 14 prosecution witnesses and only one has been
Out of
produced.
14, one.
One.
Is it?
Yes, Your Lordship. And one more ground which I have also mentioned is that his mother is suffering from serious illnesses and he is the sole breadwinner of the family, and that he may be released on bail so he may be able to attend to the medical needs of his mother as well.
Okay. Yes.
My lord, this is second round of bail appeal. I think all the other grounds have been considered in the first bail application. And the only grounds which has not been considered is that he has been in jail for almost 2 years now, 1 and 4 months. My lord, in that regard, I'd like to say that he is charged under 21C. And if if he is convicted, my lord, it's not less than 10 years. So he has been in jail only for 1 year and 4 months. And we have the witnesses, 14 witnesses, but these are all, my lord, excise personnel and from Aizawl district. So I think the trial court can have a speedy trial at this stage.
Okay, now you're saying that previously his bail was regretted and all the other points were considered. Can we have a look at that judgment?
Yes, madam.
The
The
order
bail
which
order is at page 16, 16.
Your Lordship, that is another case.
You had previously approached this court
No,
In
Your
law.
Lordship, this
for
was
the
on
same
Oh,
accused?
yes,
No,
madam.
this was another
is the
accused.
co-accused, it seems.
This is
Football alum
Co-accused.
last.
Kutbul Alam Laskar. He's the what, driver?
No,
Isn't
he
it?
was the
What?
he was arraigned as the main culprit.
Okay, he was supposed to be the main culprit and bail was regretted for him. So this is the first time he's appearing?
Yes. Your Lordship.
No, yes, madam.
Okay.
I'm sorry.
So his points, the points which he raised just now, that he's just the handyman
Yes,
and
my
he's
lord.
not involved.
With regard to that, my lord, in the complaint sheet, we can see that this case is a smuggling of a huge quantity of heroin from Champai to Aizawl in an unregistered truck. And this creates suspicions, my lord. So when the excise personnel has stopped them to look at the truck, my lord, the present applicant is the one who took out the seized articles from the secret compartment. So his involvement is very clear in this. He was caught red-handed with an unregistered truck along with the driver. So in this case, my lord, section 37 will apply. And moreover, my lord, he is not a permanent resident of Mizoram. And if he is released on bail at this stage, my lord, the trial will be delayed at this stage.
Let's see the other witnesses. The first one is the Caesar witnesses, number 1,
Yes.
isn't it?
Yes, my lord. Second and third, they are the civilian witnesses. The
From
rest
Zemabok.
are all excise personnel. This will not take time, my lord. And 12, 13, these are JMFC, Judicial Magistrate, and FSL.
Okay.
Lordship, if I may make one more submission, the learned PP has stated that trial will not take time, but the charge sheet was submitted on 22/7/2023, and till now there is only one witness has been called. So it is obvious that the trial has taken a lot of time and will also continue to take time. And regarding Your Lordship, ownership of the essay, if I may bring Your Lordship's kind attention to page number 10 of the complaint sheet. Second last slide. I perused and updated the seized bank accounts and I find out that Abdullah Burbuya, who is the rightful owner of the seized vehicle, that is Ashok Leyland, bearing so and so, used the bank account for the transaction of the cost of heroin from the previous days. So, Your Lordship, the main owner of the vehicle has also not been arrested. He is still on large. He is still at large, and they are still looking for him as well. So, him opening the secret compartment was only as per the direction of the seizing officer. So, his involvement was only to that extent of opening the secret compartment. So his
But he's the handyman, so the loading also it will be done by the handyman, isn't it? He must have been in the vehicle all this time.
And it's
Your Lordship,
21C, my lord.
it has been mentioned in the somewhat I will look it up. It has been mentioned in the complaint sheet that there was a change of vehicles as well.
Where? A handyman,
At page 9, Your Lordship.
page 9.
around the 1, 2, 3, 4, 5, 6, 7, seventh line from the bottom. I re-examined the accused persons. The accused.
Wait,
put-
wait, wait,
Okay.
seventh line. Page 9.
Page
Page 9 of what? The,
The main petition.
yes, just a sec. So it's a copy of the charge sheet, isn't
Yes,
it?
complaint sheet. Yes,
The charge sheet,
yes, Your Lordship.
page 9.
Yes.
1, 2, 3, 4, 5, 6, 7.
I re-examined.
Okay, yes.
Yes. I re-examined the accused persons. The accused Qutbul Alam Laskar stated that on 6/6 he himself, along with Nazimul Hussain and Sukur Ali Mazumdar, were sent to Champai to deposit sand balu by Abdul Barbuya from Kachar district, Assam, with his vehicle, that is Ashok Leyland, bearing so and so. On 8/6 they arrived at Champai, and on 9/6 they unloaded sand, which is received by one known as Sena, accused like Umar, who is already contacted by Abdul Barbuya. On 10/6 they departed Champai and removed registration plate of the seized vehicle, that is Ashok Leyland, and they are going to transport some amount of heroin. So, Your Lordship, in this, at this point of time, the accused, the present petitioner, was not at all mentioned or involved. So, all the loading and unloading of the heroin was done by Qutbul Alam and his associates. So,
No, but how do we know he's the handyman? They changed the registration number. He must have been there all along.
but he has not been mentioned in the complaint sheet that he was involved there.
But he's the handyman. He must have been in the vehicle all this long, isn't it? Then he then drove the vehicle. We'll regret the bail, but we will give a direction. Will to make an attempt to complete the case within maybe a period of 6 months, considering the fact that all the witnesses are from within Aizawl district, isn't it? Accordingly, we'll dismiss the bail application at this stage. Then let's see the progress. So heard and disposed by dismissing the bail application. I'll pass the full order later.
Obliged.
Item 7.
Obliged.
Yes.
My lord, I've learned that the LCRs have arrived, so the paper books will be required.
Who are the... So Ms. Zaram Sangpui had appeared previously for CBI.
In this case, she has no instructions.
I think she should find out, isn't it?
CBI, my lord, they are going to have a separate counsel. So unless she is personally instructed, she cannot appear.
Oh. Now, the previous case, are they kind of connected?
Yes, my lord. They are co-accused, in fact, with item 4.
Then I think Ms. Zaram Sangpui should find out if she's appearing for one of the accused persons, one of the appellants. Then for this also, most probably it's the same case. You can find out. Ms. Linda, did Ms. Zarim Sangpui mention anything that she's not been engaged for this case?
She has informed me just before she left.
But that's very weird. Same case.
My lord, if I may, I just inquired to Ms. Zarim Sangpui, and she told me that once the notice came, then she will be appearing. Once the notice, she has to await the notice, ma'am.
Okay, fine. So most probably she will appear.
Yes, ma'am.
Okay, Mr.
Lord
Rokuma
Rokuma
Pautu, learned counsel for the appellant is present, while none appeared for the respondents. It is submitted, full stop, it is submitted by the learned counsel for the appellant that most probably Ms. Zairam Sangpui will be appearing for the respondents. However, she has yet to receive confirmation. In view of the above, list after 3 weeks.
Right.
Item 8.
If I may, Your Lordship, I am appearing on behalf of my senior, Mr. Victor Iralte. Apparently, he's out of station for personal reasons. So, if Your Lordship may have this taken up after a week.
You're appearing on behalf of
Mr. Victor Iralte, learned counsel for the respondent.
councils. It's a whole group, isn't it? Because here it was Miss Dinari Tiazu. Yes.
Yes, my lord, I have no objection on that part, but
Okay.
I would
yes.
like to pray for permission to file additional affidavit
For what?
against the written objection.
Let them file their written objection first. They have not filed, isn't it? Or have they filed?
Yeah, they had filed written objection.
In the last order, it says that has prayed for further time. Oh, you have filed a written objection.
Your Lordship,
No,
yes.
what is the IE about?
It's continuation of delay 88
Oh, then
days.
you don't have to file a written. This is just a condonation of delay. We'll hear the matter in the next case, isn't it?
My lord, there's some need to clarify.
So, when we hear the matter, you can clarify. The points which you have raised have been countered in the written objection.
Yes, my lord.
So that's enough. You don't have to file a counter. This
No.
is just an IA
Uh,
for condonation of delay.
yes, my lord.
Okay, so you have explained why there was a delay in filing the appeal. Now they have filed the objection countering the reasons you have given for the delay in filing the appeal. Next date we can hear the matter. Why do you want a written counter affidavit? I don't think it's required. Isn't it? They must have addressed your points.
Yes, my lord. It is because.
Isn't it? How?
Yes,
What?
my lord. It's okay.
Mr.
Isak Ramdin Thara.
Isak
Ramdin Thara.
Ramdin Thara. Is it? Learned counsel for the applicant is present, along with Miss
K. Venetia, Your Lordship.
K.
Venetia.
Venecia. Any other? K. Venecia.
That's
all.
all.
Learned counsel who submits that her senior, Mr. Victor Elralte, is not able to appear today since he is out of station and has prayed for adjournment. In view of the above, list after 2 weeks.
Your Lordship. Obliged.
Item 9.
My lord, I am appearing on behalf of my senior, Mr. Johnny L. Tauchung. And my lord, he is informing me that if we may be given another 2 weeks' time for filing an affidavit in opposition for the condonation of delay, my lord, if possible.
Okay, Ms. Lalman Lui, learned government advocate, is present, along with Mr.
Lalmang Isanga,
Lalmaga Isanga, appearing on behalf of his senior, Mr.
Johnny L. Tauchung.
Johnny L. Tautong, learned counsel for the opposite party. The learned counsel for the opposite party has prayed for further time to file their written objection, which is not objected by the learned government advocate. In view of the above, list after 2 weeks.
Obliged,
Much
my lord.
obliged, Your Lordship.